Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of the Indraprasth Law College. In today's lecture, we are going to discuss about some basic main principles relating to the extradition. So first of all, let us know about that there are four basic principles which are used in the chapter of the extradition under the subject of international law as the principle of dual criminality, rule of speciality, the principle of proportional punishment, and opportunity for fair trial. So let us discuss about these principles one by one. The first one is the principle of dual criminality. In this principle, it is one of the most significant principles governing the law of extradition. It states that extradition process can only happen when the criminal act under scrutiny is an offense in both the jurisdiction of the sovereign states. The crime for which request is made by the country for extradition, that must also be a crime in the country from where the accused is being extradited. So that is the whole concept of the principle of dual criminality given in the chapter of extradition of that international law. Now the second principle is known as the name of rule of speciality. If we talk about that rule of speciality in international law, according to this rule, an accused is extradited for a particular offense and the country which requests the extradition is entitled to prosecute that person only for the crime for which he was extradited. He cannot be punished for any other offense, but can only be punished for the offense for which he is being extradited. The idea behind this rule is to prevent blanket extradition demand made by the requesting state. The rule says that the fugitive who is extradited for a certain crime should be tried for that very crime and not some other. In the judgment given by the Apex Court in the case of Daya Singh Lahoria vs. Union of India 2001, it was stated that a fugitive criminal brought in India under extradition treaty can only be tried for the offense provided in the extradition decree and not for any other offense. The criminal courts in India cannot try such fugitive under any offense other than the one allowed for trial. Now we will discuss about the third principle, that is known as the principle of proportional punishment in relating to the extradition. According to this principle of proportional punishment, extradition may be refused in cases where there is a possibility for the extradited individual to receive a punishment out of proportion or severe in form when compared to the degree of offense. This principle is specifically invoked in order to avoid violation of human rights norms accepted globally. Where there is a possibility of the death of the fugitive in the requesting state, such request is denied as per this principle to the protect and avoid violation of human rights norms internationally. Now the fourth one is known as the opportunity for fair trial in relation to the extradition. In that opportunity for fair trial principle, before the extradition process is initiated by the requested state, it is ensured that the fugitive will be given a chance to represent himself under a procedure of fair trial in the requesting state. This principle is read with the principle of non-inquiry, where the requesting state is under no obligation to subject its judicial procedures as per the punctilious evaluation criteria of the requesting state. This principle is not absolute and rigid in nature, but the requested state can question the judicial procedure in the requesting state if the same is on the face of it is against the principle of law and justice. There are the four basic or important principles given in relation to the extradition. Beside these four principles, there is also one principle of non-extradition of political criminal. Says that it is one of the most important principles of that international law that extradition for political crimes is not allowed. Most of the countries refuse to extradite the person charged for political crime. That is to say, crime committed for political purposes or crimes that are politically motivated. The practice of non-extradition for political crimes began in the French period of 1789. In the present period also, most of the states find it difficult to deal with this problem as there is not a proper definition of this offense. So these are the some basic principles which are relating to the extradition, such as the principle of dual criminality, rule of speciality, the principle of proportional punishment, rule of opportunity for fair trial, and the non-extradition of political criminal. Hope you will enjoy the whole session and enumerated it into your study very well. We will meet soon again with the next lecture. Thank you very much.